CIR vs. Toledo Power Company, 765 SCRA 511. Facts: on December 22, 2003, TPC filed with the BIR Regional District Office, RDO, number 83 an administrative claim for refund or credit of its unutilized input VAT for the taxable of year 2002 under Republic Act No. 9136 or the Electric Power Industry Reform Act of 2001, EPIRA, and the NIRC. On April 22, 2004, due to the inaction of the CIR, TPC filed with the CTA petition for review. CTA Division partially granting TPC's claim in the reduced amount. CTA and banc sustained the findings of the CTA Division that both the administrative and the judicial claims were timely filed and that TPC's non-compliance with RMO No. 5398 was not fatal to its claim. The CIR contends that TPC is not entitled to a refund or credit in the reduced amount of 7,598,279.29 pesos, representing its alleged unutilized input VAT for taxable of year 2002 because it failed to comply with the rules on exhaustion of administrative remedies. Issue 1. Whether the administrative and the judicial claims for tax refund or credit were timely and validly filed. Held, yes. Pursuant to Section 112, A, and D, of the NIRC, a taxpayer has two years from the close of the taxable quarter when the zero-rated sales were made within which to file with the CIR an administrative claim for refund or credit of unutilized input VAT attributable to such sales. The CIR, on the other hand, has 120 days from receipt of the complete documents within which to act on the administrative claim. Upon receipt of the decision, a taxpayer has 30 days within which to appeal the decision to the CTA. However, if the 120-day period expires without any decision from the CIR, the taxpayer may appeal the inaction to the CTA within 30 days from the expiration of the 120-day period. In CIR vs. San Roque Power Corporation, we said that the 120 plus 30-day period must be strictly observed except from the date of issuance of BIR ruling number DA 48903 on December 10, 2003, which allowed taxpayers to file a judicial claim without waiting for the end of the 120-day period, up to the date of promulgation of CIR vs. Aichi Forging Company of Asia, Incorporated, on October 6, 2010, where we declared that compliance with the 120 plus 30-day period is mandatory and jurisdictional. In this case, TPC applied for a claim for refund or credit of its unutilized input VAT for the taxable of year 2002 on December 22, 2003. Since the CIR did not act on its application within the 120-day period, TPC appealed the inaction on April 22, 2004. Clearly, both the administrative and the judicial claims were filed within the prescribed period provided in Section 112 of the NIRC. Also, the administrative claim was not pro forma as TPC submitted documents to support its claim for refund and even manifested its willingness to submit additional documents if necessary. The CIR, however, never requested TPC to submit additional documents. Thus, she cannot now raise the issue that TPC failed to submit the complete documents. Neither do we find the alleged failure of TPC to submit all relevant documents set out in RMO No. 5398 fatal to its claim. In CIR vs. Team Sual Corporation, formerly Marin Sual Corporation, we said that the CIR's reliance on RMO 5398 is misplaced. There is nothing in Section 112 of the NIRC, RR 388 or RMO 5398 itself that requires submission of the complete documents enumerated in RMO 5398 for a grant of a refund or credit of input VAT. The subject of RMO 5398 states that it is a checklist of documents to be submitted by a taxpayer upon audit of his tax liabilities. In this case, TSC was applying for a grant of refund or credit of its input tax. There was an allegation of an audit being conducted by the CIR. Even assuming that RMO 5398 applies, it specifically states that some documents are required to be submitted by the taxpayer if applicable. Issue 2. Whether the TPC is entitled to the full amount of its claim for tax refund or credit. Held. No TPC is not entitled to a refund or credit of unutilized input VAT attributable to its sales of electricity to SCRA, ACMC, and AFC. Section 6 of the EPIRA provides that the sale of generated power by generation companies shall be zero-rated. Section 4, X, of the same law states that a generation company refers to any person or entity authorized by the ERC to operate facilities used in the generation of electricity. Corollarily, to be entitled to a refund or credit of unutilized input VAT attributable to the sale of electricity under the EPIRA, a taxpayer must establish, 1, that it is a generation company, and, 2, that it derives sales from power generation. In this case, TPC failed to present a COC from the ERC during the trial. On partial reconsideration, TPC argued that there was no need for it to present a COC because the parties already stipulated in the JSFI that TPC is a generation company and that it became entitled to the rights under the EPIRA when it filed its application with the ERC on June 20, 2002. We find the arguments raised by TPC unavailing.